Today we're doing something different. We haven't had Lisa on for quite some time. Lisa Goetz is a Social Security disability attorney, and she's going to speak with you about, updates that there have been at Social Security, and especially since the change of power at the top of the helm. And she's going to speak with you about the Social Security disability updates, as well as how to even get into processing or filing for a claim. Okay, so Lisa's on right now, and we're going to let you all take it away.
I'm Lisa Gonzalez Goetz. I practice Social Security disability law exclusively, and the law firm name is Gonzalez & Goetz. We are out of Boca Raton, but we work nationally, even worldwide, because many clients move to other countries and they may still be eligible for disability. So for the newbies, like Stu says out there, quick overview of the program and then the changes, which are significant. Normally there are two different types of Social Security programs. There's more than two, but in general it's disability insurance benefits, eligible for people who are not able to work for 12 months or more because of a mental or physical impairment, and they have worked 20 out of 40 credits, and so they're eligible to receive what they would receive at the retirement age early based on a disability, as long as you prove disability. For that, 20 out of 40 quarters of coverage ends up being roughly, have you worked 5 out of the last 10 years before you became disabled? And that's how you may or may not be eligible for the program of disability insurance benefits, also known as Title II. So that's one type of program. And the other type of program is for individuals who have not worked or not earned enough credits and are disabled, and that's called supplemental security income. That's also known as Title 16, and to be eligible for that, you have to also show that you're disabled, unable to work for 12 months or more due to a physical or mental disability, or combination of thereof. So you also need to show for Title 16 for the SSI that you are indigent, meaning you have, at this time, indigent is defined as less than $2,000 total resources, which is a very low bar threshold, but that's the definition of indigent and poverty in this country currently. The exception to the $2,000 rule is one place you can own a property as long as you're residing in it. So you can't have a property that you're collecting rent or that you could sell for money. So it has to be a property that you are living in. That's an exception. A car that you have, or less than $2,000 total resources. Many people that are married are affected by the total income that comes in monthly and would not be eligible for SSI. But that's something that if you're wondering about, you can always reach out and we can go through the numbers and try to assign which program you may be entitled to and then apply for that program. Those are the main spheres of disability. Then there's also child disability benefits for any person who was disabled prior to age 22 and can collect under their parents, or disabled widows benefits. That's for anybody who's over age 50 and became a widow within 7 years and became disabled within those 7 years. So again, gets very technical. I'm going to try to keep it general tonight. I'm happy to answer any specific questions. And if it gets very technical, we'll have the questions afterwards. What is determining a medical condition that prevents work is really up to you and your doctor. Your diagnosis alone does not render disability for which you will receive disability benefits for. You actually have to be unable to perform any kind of substantial gainful work activity. And that can be defined by a certain amount of money that you earn a month or by working 40 hours on a sustained basis. So basically, you could be diagnosed with MS, but still be functioning and able to work. But some people, by the time they get diagnosed, are really already disabled and have not been working. Other people, just with the diagnosis, may fall into a severe depression, which would affect their concentration and their ability to work. So my advice has always been, as long as your doctors are on board with you and they believe that there's an inability to work 40 hours a week consistently, then you should apply for benefits. With MS, it's really, really specific because you don't want to decompensate with the stress of the program and the application process. We're going to get into what the process entails and the changes that they're making with the processes. But many times the delay in getting benefits, which on average is 1.5 to 2.5 years without any income, creates a lot of stress, a lot of friction with your family and friends, and deteriorates your medical condition, particularly with MS. So I would suggest to anybody who feels that they're really struggling to get to work, to speak to their doctor, to see whether their doctor would support them. As long as you have the objective findings and the support from your medical doctors, we'll do the rest, which is really show that you're not able to return to work or work any other job because of your impairment. That's not the problem. The problem is really having the assistance of the medical doctors that support you, whether they're psychiatrists for your mental impairment, or neurologists, or cardiologists, or orthopedists. Any doctor will assist, and a combination of doctors helps show that your impairments are a combination of impairments. For both programs, you have to show, very important, that you are disabled for 12 months. Some people are misinformed, and the misinformation may even come from Social Security. So it's really important to know that the 12 months is 12 months that you've stopped working, not the 12 months throughout the process. So if I last worked a month ago, had a lot of difficulty working, I can apply now, even though I don't have my 12 months, but it's expected to last 12 months or more. I should go ahead and apply now, because the 12-month will be consumed by the application process. So to wait is silly, but Social Security has misinformed individuals and said, no, you have to be out of work 12 months before filing. And that's not the truth. You have to be anticipating to be out of work for 12 months. So what I say is get your application started. And if I last worked a month ago and I decide in 4 months to go back to work and I can't do it, that application will continue. If I decide to go back to work and I'm successful at doing it, then the simple solution is a Social Security application just drops. But at least you're not wasting that time period, because delays are really, really an issue with Social Security disability. What is considered substantial work? We can help you kind of navigate that, but basically is if you can work 40 hours a week on a consistent basis, that's known as SGA work, which is substantial gainful work activity. Then there are also some parameters. Every year it changes with how much money you can earn. That's not considered substantial gainful work activity. And I have many, many people that say to me, well, I'm going to earn a couple dollars under that. There's a red flag. Those are the first people to get denied. So in our estimation, if you're going to try to work, you want to keep the amount of money that you earn well below that threshold. And that threshold changes yearly, so that's something to discuss as to when you stopped working and when you would be eligible and how much you have worked if you've worked during the process of application. Social Security has a 5-step disability process. It's pretty, seems simple, but it gets very convoluted and complicated, which is why we have Social Security disability practitioners. The first one is, are you working? Are you working above SGA? Are you working more than the amounts that you're entitled to? If you are working, you're not eligible for disability. If you are not working, then the next question is, are you not working because of a severe impairment? And then it talks about a definition of what severity is and expected to be. After you've met those two thresholds, not working and a severe impairment, then it goes into, do you equal a listing? There are several listings. You can look at them on Google. You can search them. The listing of disability impairments means if you meet each criteria, you should automatically be receiving benefits, and you should win your case at what they call step 3. However, there are many times that you get denied. We go into a hearing, you've been waiting for 2 years for this process, and we have a medical doctor saying you meet the criteria, you meet a listing of disability, and that's it. You win your case. And they should have, Social Security should have had all that medical documentation at the time of your application, and perhaps we could have gotten the benefits, or you could have gotten your benefits a lot earlier. So even though the criteria 3 seems very straightforward, it really isn't. It's perplexing to see how many offices and how many medical examiners determine whether or not you meet the listing of impairment criteria. So that's step 3. After that, the question is, can you do your past relevant work? If you have been out of work for 12 months or more, if you have a severe impairment, that's why you've been out of work. If you do not meet a listing criteria of disability, then the question is, does your impairment prevent you from working your past relevant work? And if it does prevent you from working your past relevant work, then the question is there any other job in the national economy that you can do? And if you can do another job in the national economy, then you are not disabled. But if you are unable to do your past work and any other work in the national economy, you should be given disability benefits. So it's a 5-step process. Every process has its subsections, and every subsection is very literal and technical, which is why people ask me, do you need a Social Security disability attorney or representative? And the answer is no, you really don't. But anybody who ever says you can hire an attorney or an advocate for you, it's really important to do it, because it means they're going to take something away from you. So there are representatives that and representative advocate companies that represent individuals for Social Security, and many have a lot of experience and are very well intentioned, but they're not capable of taking your case all the way. So basically, you have your initial claim. If you get denied, there's a reconsideration claim. If you get denied, we ask for a request for hearing, where we go in front of an administrative law judge. That's where most of the cases are won. If your case is not won and the judge made errors, then we go into the appeals council, which is above the judge and oversees the judges. And normally they determine whether or not there were errors, and they send the case back to another hearing. It's been my experience that in the last decade, the appeals council has mostly served as a rubber stamp to the judge's decision. So most of the cases that are denied by administrative law judges actually get or should be filed, if the judge made an error of law, to the federal court, to United States Federal District Court. And many representatives are not allowed to represent individuals in that, at that level. So I would always urge somebody to go to an attorney, and an attorney that's specializes in disability, where more than 90% of their caseload is Social Security disability, and that is licensed to appeal the cases all the way up to the United States District Court. As a footnote, recently, last summer, 2025, I worked with my husband, David Goetz, and we both got admitted to the Supreme Court of the United States. So that's where the cases would go. Theoretically, if you go into federal court and you lose and there's a mistake, the hope and the goal that we have as a law firm and in our bucket list, or my professional bucket list, is to be able to take a case to the Supreme Court and make law. And with Social Security disability, because it impacts so many people in this country, there's a good chance that the Supreme Court would allow to hear the case. So that's kind of where we're at. That's the background. That's my bucket list for anybody who's interested in that. And then I'm going to speak now very quickly about the proposed changes. So with the new administration in 2025, there was a big sweep, as most of you know, of federal employees, employees that were in the field offices. So for Social Security disability, local district offices, many of them either quit, took buyouts, or got fired. So there are different estimates as to how much the workforce decreased in these field offices, some of them being as high as 17% of the workforce in Social Security simply vanished for one reason or another. There are limits on hiring and freezes, so these 17% personnel that handles all these applications and appeals, they're not available to help process them, and they haven't had additional help. The help that they have received really and truly is a sink or swim. They have not been properly trained, most of them, to do what they're supposed to be doing. So the Social Security is in a little bit of a havoc. The Trump administration had some proposals for Social Security specifically, and I'm going to put my glasses on so that I can read it very appropriately. One of the things that they were going to do was reduce or remove the age of disability. So when you talk about work history, the biggest issue with that is, are you able to return to work? Are you able to do any other work, right? And work and your work activity and your skills and your vocational factor all also center around your age. Currently, if you're under, rule of thumb, if you're under 50 years old, it's harder for you to qualify for disability, at least vocationally. If you're between 50 and 54 years old currently, you're closely approaching advanced age, so it gets a little bit easier. If you're 55 to 59, you are at what they call advanced age, which makes it even easier, because now the question isn't, can you return to your previous job or any job? It's, can you return to your previous job or any job within the same industry where the skills are similar and they're not necessarily transferable. And then if you're 60 or above, it's close to retirement age. So the new administration, in hopes to save billions of dollars, was proposing, and it was a really strong movement, to change the eligibility of age regulation. They drafted a proposed rule that would have altered how Social Security disability and SSI disability, so Title I and Title II, the two major programs, would have been affected severely. So if you had removed or reduced the age by increasing the age of like vocational factors, this change would have resulted in a huge amount of denials for individuals applying for disability. In addition, it would have eliminated the rights of individuals currently receiving Social Security disability because they qualified under those parameters. Then it would have opened the floodgates for all those people to be appealing if their benefits were taken away. So a lot of pushback came. It was bipartisan, it was political, it was journalistic, it was national. And in December of 2025, they eliminated that proposal. That means that as of right now, the laws and the rules of age and factors are still the ones that I mentioned before: 50, 50 to 54, 55 to 60, and above 60. So if you were to look at, will I have a problem because I'm 58 years old? Will I have a problem because I'm 62 on disability, or 49 or 54? Everybody would have been affected by it had that regulation continued. But now that that proposal has been quashed, right now we're on a holding pattern.